Everyone, this is Nancy Lanard, and I am going to talk to you today about commercial leases and the legal concerns of potential tenants. And hopefully by the end of this presentation, you'll have a feel for some things that you should be looking for before you enter into a commercial lease as a retail tenant. So why is it important to use an experienced leasing attorney? Isn't it all boilerplate? People say that to me. And it isn't, by the way. They do vary from one lease to the next, the terms of them. And if you're a franchisee, you might think your franchisors negotiated the business terms, so why do you need to have more negotiations? And often I hear, well, gee, my brother or my sister or someone is an estate or a personal injury or collections or a divorce lawyer, and they can handle it for me. And hopefully by the end of this presentation, you'll see that that probably isn't the case, that there are a tremendous amount of issues in a commercial lease. They are extraordinarily negotiable documents, and pretty much every paragraph of the lease should be negotiated by someone who knows what they're looking to accomplish for you and why something is important. So let's talk about some of the terms. First of all, the rent. There's usually a couple different types of rent that'll be charged. There's the minimum rent or base rent. That's your basic rent per square foot typically. And then there's going to often be percentage rent. And in many shopping centers and mall settings, the landlord has a right to see what your earnings are, your revenues from your business every month, and charge a percentage of that to you as additional rent, or to charge it to you as additional rent. There are also extra charges, and these extra charges are called additional rent. And they can take the form of being called common area maintenance charges, which is CAM charges, or operating expenses, or just being called additional rent. They include things such as the maintenance of the shopping center or the mall, the maintenance of the common areas, for example, repairs and replacements to the roof or to plumbing systems, or painting the parking lot, or administrative charges that are part of that, or even the marketing expenses to market the shopping center. We have an exhibit of 28 items that we like to exclude from these pass-through charges. And some of them, just a few examples of those, are depreciation or amortization of the center. We don't feel that's fair to pass through to the tenants. The legal fees related to leasing the center, expenditures that are of a capital nature, repairs that are caused by landlord or by another tenant. Again, we don't think those are fair to pass through, and that's just 4 of the 28 items that we have as exclusions that we negotiate as part of our lease negotiations. We like to see a cap on these expenses, but I should say that if you're in an area where there is a great deal of snow every winter, or any snow every winter, it's unlikely that snow removal will be included in any cap. It's usually an excluded item from a cap on these expenses, because obviously some winters could be a lot worse than others and require a lot more cleanup and snow removal from year to year. We like to give our clients, who are the tenants, the right to review the landlord's books and records, and the ability to even audit them if they see that there are questions about them that they think are problematic. We feel this is a right that the tenant should have, so that they can determine that these pass-through charges are being charged properly. All of these rents and percentage rent, well, not the percentage rent, but the rents and the pass-through charges are typically charged on a prorated basis. We want to make sure that they are being charged to you properly. And so you want to have the right to have an accountant come in and review the landlord's books and records. And if they are showing something that's incorrect, that you have rights as a tenant to get that adjusted with the landlord. Taxes are typically passed through as well, and we like to see certain things eliminated from the type of taxes that should be passed through. For example, taxes based on the income from the rents received, we feel that's not fair to pass through to all the other tenants. Taxes based on the sale or the purchase of the center also seems unfair to pass through. Now let's talk about some practical issues. Maintenance. So what are the landlord's responsibilities and what are the tenant's responsibilities? Typically the landlord's responsible for the structural repairs. And repairs to the common areas, walkways, parking lots, and public bathrooms and so forth. What are structural repairs? Well, structural seems like it's pretty clear cut, but it isn't. Roof, yes, that seems pretty clear. But what about a pipe? If the pipe goes from one area into the store or the premises itself that are being leased, whose responsibility is that if it's leaking? We think that should be the landlord's responsibility. What are tenants' responsibilities? Well, typically they are taking care of the interior, repairs to any plate glass. So if any of the windows or plate glass door storefronts are cracked or chipped or broken, you must replace those. I do recommend you have insurance for that. Non-structural repairs, and typically HVAC, that's heating, ventilation, and air conditioning systems, that you usually are required to maintain those. And we like to see that the landlord certainly provides that HVAC to you in a good condition with warranties. Typically, we like to see the landlord warrant that for 1 year for repair or replacement. So another question that people would think would be very clear cut is the term. When does the term actually commence? When does this lease actually begin? And that's really important so that you know when termination is going to happen. When does this term end? When does the lease expire? And also for renewal, it's very important to understand that. Well, the lease can commence on various dates. For example, does it commence when everybody's signed the lease, the landlord and the tenant have signed the lease? Does it commence when you've been given the keys and you can start your build out? Does it commence when you've opened for business? All of those are possible, and it depends on what was negotiated in the lease. So the lease is very important, and the lease commencement is very important. There also can be a separate date for rent commencement, which could be 90 days after the lease commences or 90 days after you open for business. So again, those are all really important to make sure they are negotiated and clearly stated in the lease. What about renewal? What is the timing for the notice for renewal? Is it a wide enough window for you? Do you have enough time to be able to do that? Is it so far in advance that you wouldn't even know if you want to renew or not? How many options to renew are there? If you are looking at a value for a business down the road, when you want to maybe sell the business, you want to make sure that you have sufficient options to renew so that when you're selling it to someone, that gives value to that location. If you've built up the business at that location, the person buying it would not want to have to then move shortly after they bought the business. And defining what the rent for renewal is also very important to do up front early in the relationship before the lease is signed so that it's locked in. What about assignment and subletting? This is really important because it's very likely that somewhere down the road you might want to sell your business. And then if you sell the business, one of the assets that you're selling is the actual ability to continue in that location. So an assignment of that lease to the new buyer would be very important. Do you have a right to assign? And what are the landlord's rights to put conditions on that assignment? Typically, if you're a franchise, we like to try and see that you have the right to assign to the franchisor or to other franchisees in the system unconditionally without any fee to the landlord. Also very important, to me, one of the most important issues is that upon an assignment, that you're released both as a tenant and as a personal guarantor of the lease. So that's really important. You don't want to sell your business and then find that you're still on the hook for the rent and as a personal guarantor of the rent if your buyer then defaults down the road. So that's really important. What about the use? You want to make sure that the use is broad enough to encompass everything that you intend to sell. So, for example, if you are in the business of, your hair salon and you're in a hair salon business, is it broad enough use? Does it just say hair salon, or are you allowed to sell products? Are you allowed to sell maybe a t-shirt that even has the hair salon name and logo on it? You want to be able to sell everything, including all ancillary type of products and services that you can envision down the road, maybe wanting to sell at that business. And do you have an exclusive use? Is there going to be 5 other hair salons in the shopping center, or are you going to be the only one? And is there a penalty upon the landlord if they fail to comply? What are your rights? You should be able to reduce rents if monthly rent if they put in some other competing business. What about signage? Obviously, that's critical to any retail business. You want to make sure that you have the landlord's approval. I recommend that that even happens prior to signing the lease, and that way there's no issue down the road that the landlord has approved your sign. What about governmental approval? Typically, the local municipality will have the right to approve your sign, and if they don't, that can materially impact your business. So you would really want to have the right to terminate the lease if you can't get that governmental approval. What about permits? Typically for your build out, you're going to need to have certain permits. And if you don't have the right to get these permits, you should have the right to terminate the lease if you can't get these permits within a certain specified time, such as 30 days or 60 days after applying. Because if you can't get the permits, you can't do the build out, then you obviously have an issue and you're not going to be able to get the space. I had a client at one point who actually was looking to put in a facility, and the town, the municipality, actually had a moratorium, a hold, a freeze on additional bathrooms in any facility because of their, I guess, their water situation in the municipality or something with the plumbing. Whatever it was, they couldn't put in additional bathrooms, which meant they couldn't be up to code, which means they couldn't do the purpose for which they intended to have the space. So they needed to be able to back out. And because of the provision in the lease that said that they could back out for permits, if they couldn't get permits, they were able to terminate the lease without a penalty. So what are some of the legal concerns? Well, one of the things is certainly if there's hazardous materials. We would want to get some sort of a warranty and representation and even indemnification from the landlord for both the center and your particular premises that this is free and clear of hazardous substances. And we want to make sure that any indemnification that a tenant's required to give is certainly narrow because, you're not doing an environmental study. But chances are pretty likely that the landlord, in order to get any kind of financing, has done an environmental study of that land. We want to see a warranty and representation from the landlord that the center and your premises are in compliance with the Americans with Disability Act at the time that that premises is turned over to you. What are the default and remedies? We want to make sure that you're given sufficient notice and an opportunity to cure or fix a default. We want you to have also the notice for monetary default versus non-monetary default may be different. Might be that you get 5 days notice of a monetary default and an opportunity to cure it, but you might get 30 days notice for a non-monetary default, a default that doesn't have anything to do with handing dollars over to the landlord. In Pennsylvania, we have a very odd clause called confession of judgment. It's pretty unique to our state here in Pennsylvania, but it's a pretty great landlord remedy and a pretty harsh one for a tenant. And basically it says that by signing the lease, you've, quote, confessed judgment against yourself, and the landlord can go into court, prove that you were in default unilaterally without you having a right to defend yourself, and upon that proof, get a judgment against you. So that's a pretty harsh remedy that a landlord has in Pennsylvania, and obviously something that we try very hard to negotiate. Remedies, typical remedies all over the country are that the lease will terminate and there might be an acceleration of the rent, meaning that all remaining rent will then be due at the time that that default is happening. Sometimes they can accelerate the rent without terminating, meaning you're still on the hook for everything, but they're going to accelerate the rental payments. Sometimes the landlord has the right to come in and remove your property, your business assets from the property, and sell that property by having a security interest on the property. What else should we be worried about? Well, what are the remedies that you have against the landlord if the landlord's in default? Do you have a right to abate or reduce rent or even stop paying rent for a period of time until the landlord fixes whatever it is that their obligation is? For example, the landlord's obligated to do structural repairs and doesn't do something that, like a roof that's leaking, that is landlord's responsibility, do you have a right to stop paying rent until that's fixed? What about a personal guarantee? You know, more and more since the recession in 2008, landlords are definitely requiring personal guarantees, and especially by franchisees and new businesses and so forth. So we try very hard to limit them. There are many, many ways that personal guarantees can be limited. And again, that goes back to the assignment. You certainly want to be released from that personal guarantee if the lease is assigned. We like to see are all of the terms of the letter of intent actually included in the lease. You'd be amazed how many times people work with a real estate agent or franchise real estate person and develop a great letter of intent, and then lo and behold, we go look through the lease and the terms of that letter of intent are not included in the lease. What about insurance? Are the insurance provisions in the lease reasonable, or are they asking for you to have $10 million coverage when really you should only have to have $1 million in coverage? Alterations. Are you free to make alterations, or do you need to get the landlord's consent before you make those alterations? And what happens at the end of the lease to those alterations? Can you take them with you, or do they become part of the property? All of those kinds of things are just a tip of the iceberg of the types of things that we look at in a commercial lease. So hopefully you've realized that leases are not boilerplate, and that the legal review can uncover many issues and concerns that the general business negotiations by the real estate agent or the franchisor won't really deal with, and that an experienced attorney understands which issues are important and the ways to negotiate them. We charge a flat fee for commercial lease review. We think it's a very fair fee, and it's very comprehensive, and includes the negotiations of the lease all the way up through the time that you're ready to sign the lease. So contact me, Nancy Lanard. That's my name, my phone number. We're here to help, and we would love the opportunity to help you. So please call me with any questions that you might have. We handle commercial lease nationwide, and my full contact information is on this last slide, and I would love the opportunity to hear from you and to work with you. So I hope you've enjoyed this presentation, and look forward to the opportunity to hear from you.